Good morning and welcome to this morning's Knowledge Bank. Happy New Year. Thank you for joining us for our first Knowledge Bank of 2024. Today's webinar is being presented by Mark North and Faruq Kasu from Brethertons, and they are covering recovering service charges. If you have any questions throughout the webinar, please submit them in the Q&A box at the bottom of your screen, and we will try to get through as many as possible at the end. The session is also being recorded today, so you will be able to watch that back via our YouTube channel this afternoon. Other than that, I will now hand you over to Mark and Faruq.
Brilliant. Thank you very much, Vicky. And thank you to News on the Block for allowing us this opportunity to talk to you guys today. And as Vicky said, we're going to talk to you about recovering service charges. Now, before we do, let me make sure that moves on. There we go. Before we do, probably a good thing to introduce ourselves. Would you like to go first, Faruq?
Hi, everyone. I'm Faruq Kasu. I'm an associate at Brethertons Solicitors in our award-winning property management team. My day-to-day job involves recovering service charges in the county court and also in the first-year tribunal. I'll pass it over to my handsome colleague who'll introduce himself.
Handsome colleague. Brilliant solicitor, clearly short-sighted. For those of you who don't know me, my name's Mark North. I'm business development partner at Brethertons Solicitors. I've been in property since the dawn of time, I think, certainly since 1991. I've been an estate agent, a letting agent. This is my second stint at Brethertons, totaling about 14 years. And in between time, I spent 5 brilliant years at managing agents, teaching their staff to do property management stuff. So hopefully that gives us a bit of credibility to talk to you today. We are lawyers, unfortunately, and it does come with a disclaimer. So what is this all about, mate?
In short, guys, please treat the content of this webinar for information purposes only. Please don't act or take any action based on its contents unless you've taken legal advice. You know, we're here for a reason. Give us a shout if there's anything we can support you with. We can't accept any sort of responsibility for any errors or inaccuracies based on the back of any sort of action that's taken following this webinar or on the basis of this webinar.
Yeah, absolutely. And don't forget the date. It's the 16th of January 2024. And if you're watching the recording in November or in 2025, things might have moved on. So let's leave the disclaimer behind. Let's move on from that. What are we going to look at today? What are our objectives? Well, we're talking about recovering service charges. So it's important to have a look at this picture as an absolute whole. So we're going to start off very, very briefly looking at what success is in property management. And then we're going to look at something that we're referring to as a very important piece of paper. If you're going to recover service charges, then you've got to get the accounting side of things right. So we'll look at that as well. Before we look at the referral to debt collection, so to solicitors or debt collectors, the debt collection process, and then what happens when things don't go quite according to plan. The end goal, of course, is all about getting paid. Vicky said it earlier on. This is a Q&A as well, so there will be questions hopefully at the end. So we've left a few minutes, so please stick those in the Q&A box. Right, what is success in property management? I think if I asked you that question, you'd probably come up with a number of different things. Well, Faruq and I sat down and we had a look at this, and we think there are a number of things, number of elements that make up success in property management. You know, you are successful if you can increase your stock levels, or maybe it's just about retaining stock levels. If you've got motivated and engaged staff, you are successful. If you've got an efficient and prompt credit control process that gives you a good cash flow, that leads on to great contractor relationships because actually you've got the money to pay your contractors. Good contractor relationships enable well-run developments. Well-run developments lead to happy stakeholders. That leads to certainly retention of stock. Maybe you get referrals leading to an increase in stock. You then end up with motivated and engaged staff, and you can see where I'm going with this cycle. So you can start that process anywhere around that little circle of success. We're going to look at those two bottom ones, the efficient prompt credit control process and good cash flow, and how we can support you with that. Before we get into all of that, I want to talk about something. I want to introduce you to a little concept, 4 little letters, RTBL. Now, anybody that's known me for a number of years will know exactly what that is, and it's incredibly important to property management. It's not mine. I didn't make this up. I actually came across this many years ago at a conference, and I've heard this spouted at various conferences over a number of years. So RTBL, if you take nothing else from the beginning part of this webinar, make sure you write this down if you've got a pen and paper. Read the bloomin' lease. The lease is, as it says up there, all important. It's one of the most important documents that you are going to need, particularly if you are looking to make a successful recovery of service charge. Now, the lease actually covers everything from the financial perspective, where it provides all that information. It tells you what your service charge year is. It gives you all the information you need for budgeting purposes. What are your demand dates and your end of year? So when do you need to do your end of year accounts? All of your financial information is going to be found within the pages of the lease, along with all the other bits and pieces as well. Subletting requirements, so whether you can have a pet, what you need to do when you assign the property, and much, much more.
And let's not forget the legislative requirements also. More on that in a little bit.
Absolutely, indeed. Right, let's have a look at the front end of this. Okay, so no point talking about when things go wrong if we haven't got the front end of this completely right. So we're going to look at budgets, demands, and accounts. Let's start with the budget. You know, what is a budget in its very simplest form? In order to understand that, I went to a really reliable source of information, and Google told me that a budget is an estimate of income and expenditure over a set period of time. And I reckon if I asked anyone to give me a definition of a budget, that's probably as close to a definition as you would give me. But there is a really important part in that sentence that I want to highlight with you, and it's this. It's the word estimate. It's an estimate of income and expenditure. It isn't an exact science. And when it comes to recovering service charges, I think sometimes our clients and our stakeholders, our leaseholders, they don't fully appreciate that it is an estimate and can only be an estimate. So what is then the purpose of the budget in that respect? Well, it's to manage people's expectations, those expectations of our clients and our leaseholders. It's there so that we can say to them, this is an estimate in part. We are going to be asking you to pay towards a budget where there are sums that are not necessarily listed against particular items. So we have to try and manage those expectations as best we can. It supports the level of demand that you're going to provide. So you're sending out your budget. This is all the bits and pieces we expect to pay out over the coming year. And this here is your share of that budget. So when you're putting your budget together, then clearly it's going to be based on a couple of things. It's going to be based on an assessment of expected cost and estimated cost. The expected ones are all the things we know. We know how much it's going to cost to insure because we get a quote. We know how much it's going to cost to do the gardening or the cleaning because we get quote. And then this estimated element. So we're going to use all the information available to us at that time to compose that budget. We're probably going to use prior year budgets. We're going to use previous year's accounts in order to understand peaks and troughs and look at pattern of costs. And it's really important to see where I've put that apostrophe. It's S apostrophe, not apostrophe S. So we're not talking about last year only. We're talking about last year, the year before, and the year before that. There's probably going to be lots of site visits done, going down on site, having a good look round, seeing if there's anything that needs doing in the coming year that people haven't told you about, maybe health and safety issues or just general maintenance issues. So we need to be getting that budget absolutely right, because all of this is going to have an impact on you recovering your service charge. There's been lots of client communication. Are you happy with the cleaners? Are you happy with the gardeners? And so on and so forth. As property managers, we're going to be looking at the minutes of various meetings, AGMs, directors meetings, maybe development meetings, and seeing whether there is anything that's been agreed at those meetings that we need to do in the following year. And that won't necessarily have appeared in last year's budget or the budget before. So we may need to be sending out a covering letter which details these additional costs. Again, it's all about managing those expectations of our leaseholders so that we are ruling out or preventing, heading off, if you like, any problems further down the line. We must have an appropriate unallocated amount to cover the estimated costs element. And again, this is where people, I think, sometimes get a bit confused. You know, what is this general repairs element that you've put into the budget? I don't understand it. It doesn't relate to anything. You know, it's a sizable amount of money. I'm not paying that. Well, if people understand what general repairs actually is, then you kind of get over those queries before people raise them. Maybe look at breaking general repairs down into different elements: general repairs, internal common parts; general repairs, external common parts; general repairs, electrical, or something along those lines, just to give people a bit of a better idea, rather than this kind of general repairs, it could be anything.
The key message to take away from this is to just ensure that you're transparent and you're able to communicate exactly what you're spending that budget on, or what your intentions are, and just be as transparent and as clear as you can with your leaseholders.
Absolutely, and that's the sort of thing that's going to stop people from having issues and raising complaints. The other thing I think sometimes we get picked up on the reserve fund and sinking fund. You know, it's clearly we need to have reserve funds and sinking funds in order to prep for costs further down the line. But we should only have that where the lease permits. And again, we probably need a bit of educating from our leaseholders, or educating our leaseholders, I should say, in what that is for. Because again, they don't necessarily understand why we're putting aside this amount of money. Whatever happens, that budget has to have sufficient detail in it to enable leaseholders to understand why we're asking them to pay the amount that we're asking them to pay. So our budgets have got to be full of not just numbers and line items, but relevant notes telling people exactly what is being done at that development. All of this is going to help with recovering service charge. Let's have a look at the demand. Now, we've already mentioned RTBL, read the what's it lease. We're going to obviously be checking our lease to make sure that there are no special provisions, or if there are special provisions when we demand, that we're complying with those. We need to make sure we know when our demand dates are. Faruq, I think one of the things that perhaps does fox people on occasions is this, Section 47 of the Landlord and Tenant Act 1987. What is it exactly, please?
In short, within our demand, we want to identify and inform our leaseholders exactly who their landlord is, and also provide an address. If that address is not in England and Wales, we need to provide an address which they can issue notices to in England and Wales. References to the landlord include the RTM company. It's very important to recognise that if a tenant has not been provided this information within the demand, they're not liable to pay the charges until the landlord complies. It's also important to understand that Section 47 is only relevant in instances within the lease where the service charge is payable to the landlord. In circumstances where the service charge is payable to a management company, Section 47 does not apply.
Okay, so we need to be making sure we comply with Section 47, putting the landlord's name and address and an address for service on there, or we've not got a compliant demand. If we send out a non-compliant demand, just something that's occurred to me, can we rectify that?
The liability for the leaseholder to pay a service charge is not extinguished. It's only suspended by not sending a valid demand. So once you provide a notice informing your leaseholders of who their landlord is and providing them with the address details, that invalid demand now becomes valid.
Okay, so it's not valid.
No.
All right, so we're going to send out our valid demands, and there are some things that we need to enclose with that. We need to enclose a summary of rights and obligations. Again, same question as before. What's a summary of rights and obligations?
In short, it summarises the leaseholders' rights and obligations. It informs them of their ability, of the fact that the summary of rights and obligations needs to accompany a demand. It also informs them that the service charges can be challenged by referring the matter to the FTT. It's also important to understand that the summary must be legible. It must be written or in printed form, and at least font size 10. Once again, the tenant is not liable to pay the charges until the landlord complies.
The summary of rights and obligations has been around for quite some time, and it's changed over the years. In fact, if you look at the regulations, which are still online, it still references the LVT, the Leasehold Valuation Tribunal. So the document is a prescribed document. You have to use the wording that's in the regulations. Other than the fact you have to take out the word LVT and substitute that with first tier tribunal. That was something that changed a little while ago. They didn't really bother to tell anybody that we had to update it.
Yeah, it's really strange that the FTT is still relevant in England. However, the LVT is still recognised as the body to determine the service charges in Wales.
Right, so we have to tell everybody it's the First Tier Tribunal, and yet it's the LVT in Wales. Anyway, okay, let's move on from that. Right, so we talked about our budget, that's all front-end stuff. We talked about our demand, that's early in the year. We're going to skip ahead very quickly and look at the accounts. Now, leaseholders, Faruq, should be given an annual statement. What are we expected to enclose within that?
It's a summary of the costs and expenditure incurred over the calendar year. As per the lease. It provides a statement of any balance that's due. The accounts need to be transparent. They need to reflect all expenditure in respect of the accounting period. And the best practice involves using, as Mark mentioned with the budgets, using prior year numbers and budgeted figures.
Okay, so we're lumping everything into that basically. So we're taking all the budgets, the demands, the contractors' invoices and things, and then we're producing end of year.
That's right.
Now, one of the things we need to be careful, particularly at that stage, are items that we haven't perhaps demanded, where we're going to need payment of. And this is where we start to see commonly used terms such as Section 20B notice, or people referencing the 18 months rule. So what are they and where do they come into play?
The rule's been designed to assist leaseholders in not being faced with a demand or incurring an expense which we weren't expecting. We're required under Section 20B of the Landlord and Tenant Act to inform leaseholders of any costs that are incurred and demand for payment within 18 months. If we can't comply with the 18 months, the tenant's not liable to make payment. The costs are therefore not recoverable.
Okay, so what we're saying here is that if we incur a cost that we haven't yet demanded for, we have 18 months in order to pay that. So we're not talking about on-account payments here. So our demands for our forthcoming service charges, that doesn't fall within this. So this is very much towards the year end. So if we were to under budget, if we were to say budget for 50,000, but we know we're going to spend 55, we've got this £5,000. So most managing agents will work in the same way. They'll try and get their accounts finalised within 6 months of the year end. So they'll be nicely within that period. I guess it's where you've got a situation where you can't actually finalise those accounts. And we run the risk of not being able to recover those funds. If we serve this Section 20B2 notice, that almost effectively puts time on stop, doesn't it?
That's right, it stops the clock. So we need to inform our leaseholders under Section 22B, Section 20B2, that a cost has been incurred and they will be notified of that in due time.
Okay. So from our perspective then, if you want to recover service charges and you want to do it in the right way, then it's essential to have this robust credit control process in place. But it's more than that, it goes further than that. It goes all the way back to the beginning. We need to make sure that we're budgeting right. So if we're budgeting right and we are confident about the figures that are in there, and our clients are adopting a confidently put together budget, and we're explaining to our leaseholders sending them out a really good document which is very detailed with a lovely covering letter, you're beginning at that point then to start to reduce the problems that you're going to see further down the line. And of course, we're talking about this in an ideal world. And we don't necessarily live in an ideal world, but if we can get that front end right, then we're on to a bit of a winner. If we demand right and we enclose the right things within our demands, if we demand on the right days in the right financial year, again, all of this is going to help to recover service charge. You want to get into a situation where, ideally you don't need the likes of Faruq and I. It's not ideal for Faruq and I, obviously, but you don't need people like us to then chase service charges. Everybody is happy. Of course, we don't live in an ideal world, and people aren't happy all the time. So we do need to speak about this. We do need to speak about what happens when you guys have kind of exhausted all the avenues you can. When something comes across to us, we of course have protocols and legislation that we need to comply with, and one of those is the pre-action protocol for debt claims. What is the pre-action protocol, please, and what does it look to achieve?
The pre-action protocol applies to any business seeking a debt from an individual. It was introduced to encourage early engagement and communication between the parties. The court views litigation as a last resort. So the pre-action protocols was introduced to try and enable a resolution without starting court proceedings. It takes into account parties' reasonableness and the way they conduct themselves, and deals with proportionality. It supports the efficient management of proceedings that cannot be avoided.
Okay, so effectively what we're trying to do here is stay out of the courts. The law doesn't necessarily want us to get to the court. They want us to do everything in our power to close out an issue before it even gets to the court. Well, the first stage that we have to do as lawyers is send a letter of claim, and that's quite specific. Again, there's quite a bit of detail that goes into that. So when we send our letter of claim to the debtor, what information do we have to enclose?
Within our letter of claim, it will detail the amount of the debt. This will include a breakdown of the service charge and interest elements of the debt. It will also make reference to a lease, the parties to it, and make it very clear that said copy of the lease or transfer can be available upon request. It encloses details of how the debt can be paid and how to proceed if the debtor wishes to discuss payment options with us. The address to which the completed reply form is also enclosed within that document.
Okay, so there's a fair amount of information that we're including. And much like with the demand, we also have to send some paperwork along with that as well. So what must we accompany the letter of claim with?
The debt may accrue over various periods, and it's important for us to include an up-to-date statement of account. The up-to-date statement of account will set out very clearly what periods that debt is in relation to. It also includes an information sheet and a reply form, enabling the leaseholder to make contact with us and encourage that engagement. There's also a financial statement form included within our letter of claims. This allows the leaseholder to put forward their financial circumstances, which may be the reason why they're not making payment. Within the information sheet are also details of organisations which the debtor can make contact with if he wishes or she wishes to seek debt advice.
Okay. Now, it's important that we serve this letter properly and make sure that it's getting to its destination. So how do we serve the letter of claim?
Long gone are the days where we'll be printing these letters of claim, putting them in an envelope and sending them in the post. And we outsource our postal responsibilities using an entity which is able to send out the letter of claims. Not only are we able to, the question you guys are probably familiar with is, when did you send me the demand? Oh, when was the letter of claim sent? We can provide that information using this third-party outsourcing system that we use. They're able to provide us with not only the date and the time that the letter of claim was sent, but also the documents which are enclosed within the letter of claim.
Okay, so we do still send it by post, but we don't physically do it. We don't walk out to the post box. So that third party then, they will tell us the date and the time that left the building, and they keep a record of what was enclosed in there. So there's absolutely no grey areas in this at all. We don't just send it to one address. We can send it to multiple addresses if needs be.
When instructed, if we're provided with further addresses which you might have extracted over the years, you're able to provide us with that information. We can send it to all sorts of different addresses to maximize that contact and engagement with the leaseholders. If you have an email address, we also send a copy via email as well.
Okay, well, touching on email then, what if the debtor has made a request before that they don't want anything to go by post, and here's the email address that everything's going to? What do we do then?
Where a debtor has made an explicit request, correspondence shouldn't be sent in the post. We need to respect that and ensure that we send it by alternative contact.
Okay. Right, so we send the letter of claim in. Now, we have to allow 30 days, right there in bold. We've got to allow 30 days for the debtor to respond, and we've got to take into account any kind of postal delays. That's a heck of a long time when you think how long these service charges are potentially outstanding anyway. You know, we'll have demanded ahead of time, we'll have given them time to pay, we'll have chased them, 2 or 3 times at least. So another 30 days just sitting on your hands, that's a long time. Do we not do anything in that period of time?
Of course we do, Mark. We have a very experienced payments desk team that on day 7 of the letter of claim being sent out will contact the leaseholders if we have a telephone number for them. They'll try and understand the reasons for non-payment and see if they're able to resolve this at first instance.
Cool. That was a really slick question and answer. We rehearsed it. Right. But what about the managing agents? Because one of the things that we know from the past, as soon as a leaseholder, as soon as a debtor gets this letter of claim, they're going to do absolutely everything to circumnavigate this process, and they're going to make contact with the agent. So what should managing agents do?
feel free to say, let us deal with this. You've instructed us because you've maximized your efforts to engage with this particular leaseholder. If a leaseholder still contacts yourselves or sends you any emails, by all means, feel free to forward that email on to us, or if you've got them on the phone and you're able to transfer the call, please do so.
Don't allow them to play one off against the other. You know, if they are looking at making payment, great. Let's just make sure that the payment includes everything that we've asked them to pay. Right. What happens when a debtor fails to respond?
Well, technically, we're now in a position where a claim can be issued, but that's not always what we do, is it not?
No, certainly isn't. We're going to talk about that in just a second. But let's look at the flip side of that. So rather than if the debtor doesn't respond, let's have a look at what happens when they do respond. So when the debtor does respond, and they should be using the reply form to send to us, what sort of things are they making contact with us about at this stage?
They could be informing us at this stage about their reasons for non-payment. They could be asking for us to provide any sort of documentation which may help the situation. Also, if they are requesting us for the documents, so let's say, for example, they want a copy of the lease or transfer, we need to be able to provide that document to them within 30 days, or provide a reason to them why that documentation is not available, or it cannot be provided.
That's quite a frequent thing. They ask for a copy of the lease, a copy of the document that they would have signed when they bought the property, but we still need to provide it to them, or at least tell them why we can't. This is the point where they may suggest that they're seeking debt advice. We've obviously provided them with a variety of different places to go. We've got to allow a reasonable period of time for that to happen.
This may be the first time that a debtor looks at the information sheet and sees that there are advice agencies that may be able to assist. If they respond to us, informing us that they are seeking debt advice, then we need to ensure we give them a reasonable time to do so.
We're talking as though the debtor is requiring additional information or seeking debt advice. They might be looking to pay, but if they're not looking to pay in one lump sum, they might be looking at a payment option. We should certainly consider payment options. Should we be saying that we need to be bound by those payment options?
No, not necessarily. We need to ensure that if a reasonable proposal for payment has been forthcoming from the debtor, we need to kind of dissect that and look at whether that payment proposal is reasonable. I'm not saying somebody who's wishing to pay £10 a month for a debt of £5,000 is going to be acceptable. What I'm trying to say is that, for example, if somebody's proposing to pay over 3 months, if we were to proceed with this matter, it's going to take more than 3 months to get anywhere near a hearing, and therefore it may be reasonable to accept it.
Okay, so case by case example.
I would say so.
Okay. The other part of the pre-action protocol is that the courts do expect us to be able to resolve this dispute through alternative means, or alternative dispute resolution, as it's called. So what is this essentially? What are those means?
If you think about the court as a last resort, this is exactly what it says in the title: an alternative dispute resolution option. It doesn't need to take any formal stance at this stage. It could just be a telephone call. It could be a roundtable meeting which is set up. It could be simply a discussion, a negotiation, trying to resolve the matters. Mediation needs to be considered, and also the reasonableness of the costs incurred in proceeding with mediation. But it's a good avenue to demonstrate to the court, literally, we've exhausted all our options to try and resolve this matter without proceeding.
Okay. But whatever happens, if we reach an agreement, we've got to allow the leaseholder the opportunity to comply with that agreement. If they fail, then I'm guessing it's fair game. We can just continue.
Correct.
Okay. Right. So we've just talked about all the things that we've got to do, and I do appreciate, that there could be some frustration, certainly amongst clients. The debt's been outstanding for a while. Let's just push it on. Do we really need to do that? The answer is yes, we do. The court are going to expect to see people have complied with this. What sort of sanctions might we be facing if we don't?
Let's say if we're in a position where the debt's been outstanding for so long, I can understand your frustration with the periods, and also to get to this stage, you might be, in 10 days, I want you to issue a claim. Albeit we're trying to rush the process and not comply with the pre-action protocol, we could be in a position where the court looks at our conduct and says, actually, that's not on. You need to now go back and stay the matter. So albeit we've tried to push ahead, the matter's actually now been stayed in order for us to go back and comply with the pre-action protocol, which we should have done at the start.
So could you end up with like wasted costs order, leaseholders claim costs against us?
Exactly that. If the leaseholder sought legal advice and then put this position forward, it could be a situation where we're faced with a costs order.
So we're bound by this. We've got to run through this, whatever we do. Said earlier on, what happens when the leaseholder doesn't reply? And you said technically we can issue proceedings, but we don't do that. We kind of left people on a bit of an EastEnders cliffhanger. So let's, I don't think it's as exciting as EastEnders, although I've not watched it for years. But what is that cliffhanger? It's this, isn't it? We need to be going on to another stage. We need to be doing whatever else we can to get this money returned. And one of the things that we're going to do is we're going to look at the office copy entries. We're going to understand if there's a mortgage company attached to that with a charge over the property, and we're going to write to the mortgage company. Why are we going to do that?
The mortgage company is going to be concerned about the leaseholder possibly being in breach of their mortgage arrangement. If they're not paying the service charges as per the lease, maybe it could have an effect on their mortgage policy. Also, the other thing is we've maximized our efforts to contact this leaseholder. If there's one entity that you're going to update with your whereabouts, who do you think that's going to be, Mark?
Yeah, well, it's going to be your finances, your bank, your mortgage company.
The other issue also is that it may make them feel that there may be a risk over their security of the property.
Okay. So we're effectively, you know, it's again trying to provoke a response from the leaseholder, or maybe even in some cases, mortgage company might step in, I guess, and make payment as well. Okay. All right. So that's a good avenue for us to go through. If everything else fails, then we're left with no choice but to issue proceedings. So court action is required. But it's probably worth noting at this point that certainly from our perspective, we know that about 80% of cases actually complete before we even get to issues of proceedings. So anything that comes across to us, we'll send that letter of claim, we'll write to the mortgage company, and about 80% of cases will close out at that point. We've still got 20% of cases that we need to issue proceedings on. And we do that through money claims online. We used to do that by sending bits of paper out in the post to the courts. And why did we change to money claims online, and why is that a benefit to our clients?
There seems to be a massive backlog these days with issuing a paper claim. It takes various days, as you can see with the useful infogram there, by the time that claim's been issued. Money claims online allows us to submit the claim and it's issued immediately.
Yeah, it is a timescale. So, I mean, issuing a new claim, 10 working days, that's long enough. But when you look down the line, you get to that sort of second from bottom, entering judgment, 35 working days. That's 35 working days. That's 7 weeks. If we were to issue that today, we wouldn't get judgment until the beginning of March. That's horrifically long.
It's insane. The other crazy thing about it is you could be in a position where you could request judgment, but you do it using the paper form and through the post. And by the time the court have actually processed it, they may have processed a defence or acknowledgement of service beforehand. So you've lost your ability to enter judgment. Money claims online allows us to request judgment immediately, and it's entered the next day.
So we're issuing proceedings online. That is more efficient. It's time saver. It also means we're not sending out quite as much paper as we used to, which is always a good sign. We're including at that stage all service charges outstanding, any legal costs up to that date, interest, of course, if that's recoverable under lease or through statute. And so we're literally encapsulating everything at that point.
That's correct.
Okay. Once we've got our judgment, if we've still not got any contact from the leaseholder, we need to look to enforce that judgment, because obviously, you know, that doesn't just indicate we're going to get payment. What are our sort of main options?
So there are a number of options here. We review the matters on a case-by-case basis, and we'll be able to advise you as soon as we have judgment, even beforehand, which enforcement option may be best placed for your particular leaseholder. If we're acting on behalf of the landlord, we may have the option to issue a Section 146 notice informing the leaseholder that actually we're now looking at forfeiting the lease. And if there's a mortgage company involved, then security is now at more further risk. Another option is a third-party debt order, where we're able to contact the bank or institution where we're aware that there are monies in the account, freeze those accounts in order to discharge the amount that's due under the judgment. if we're aware that the leaseholder is residing at the property, High Court enforcement may be a good option to choose. It enables the High Court enforcement team would transfer our judgment to obtain a writ of control and make an attendance at the property. You've probably all heard of can't pay, will take it away. Similar sort of action. It may be a case that we're able to obtain a charging order over the property. Now, a charging order doesn't necessarily mean immediate payment. It's important for us at this stage to kind of recognize any sort of parties that have a registered charge, which may appear prior to your charge over the property. And if it's possible, maybe we may proceed with an order for sale.
That charging order, I've seen that fairly recently. Another solicitor obtained a charging order for a debt, and there were already half a dozen charge holders, including a mortgage company. So you have to wonder, if there's very limited equity in that property, there's limited opportunity of getting debt back. What you're saying here then is these options that people have, they're very much, again, case by case basis. So you would look at the situation, or one of the managers in the office would look at the situation and advise our client what we believe to be the right course.
Exactly that, Mark. We try and take a position quite early on where we see this is headed, and kind of look at, well, if we're going to go down this route, these are the options that are available to us once we've obtained a judgment.
Listening to you talk then, all of this stuff seems to be quite hard hitting, and there may be people there that sort of think this is particularly harsh when we get to this point, forfeiting someone's lease, taking money out of their bank account because the law says we can, having somebody turn up on your doorstep, so on and so forth. But this is quite far down the line, isn't it? I mean, we're talking about a very small percentage of people. We've sent a demand. We've sent 2 or 3 chasing letters. We've sent a letter of claim. We've issued proceedings. We've had loads of opportunity for somebody to actually make contact and say, can we stop this now and come to an arrangement? So these do feel quite harsh in their what they're looking to achieve. But there is no other way forward, is there?
No, you obviously need the monies recovered because you need to look after the development that you're responsible for. And albeit these may sound quite harsh, we've exhausted all the other possible options, and the court will recognise that before we even get to this stage.
So the reality of things. Okay, look, there are occasions where we issue proceedings where the leaseholder does suddenly appear, or maybe they've been there all along and they've just not made payment. So we end up with a defended matter. How do we deal with defended matters? What's that process look like?
This, like you said, Mark, this may be the first time we've heard from our leaseholder during this process. It's a good opportunity for us to review our hand, in a sense. For those of you that play poker, it might be a good opportunity for us to see if there's any merit in why the matter's now been disputed or defended. It may be an opportunity. It is an opportunity for us to review, do a risk assessment, to review the terms in the lease, to ensure if there is any merit, are we able to resolve these issues at an earlier stage? The first documentation we received from the court, accompanied with the defence, is a notice of proposed allocation. So the court will kind of look at the values involved and also the complexity of the issue and allocate it to a track. We're then required to file and serve a directions questionnaire, which means basically we file a copy of the directions questionnaire with the court and also serve it on the leaseholder. It enables us to kind of activate the ADR provisions again. So if the matter has been allocated to the small claims track, within the directions questionnaire, there's an option for us to say, yes, we're happy for it to mediate a matter on the small claims track, and allows us to arrange for a small claims mediation appointment, which is free. Also, if it falls on a different track, it allows us to go back to the court and say, actually, we're going to try and resolve this matter again and request a further stay. Once those options have all been exhausted, we'll receive case management directions from the court informing us of a trial fee being due, witness evidence, and the date of the hearing, which may be remote or face-to-face.
So when we get the defence through, this is still an opportunity to close out that case, even without getting into a court. Again, you kind of hear clients in the background sort of saying, mediate again. We've tried negotiating with these people. You've tried negotiating with these people. Now the courts want us to mediate once again. But that defence, there may be things in that defence that they haven't said to us before, which either have merit or actually it is clear misunderstanding on their part. Getting in front of a mediator may help us to explain them. I just want to touch very quickly on this point 5 about the hearing, because this I think is an area where certainly property managers, credit controllers might be more concerned, because it doesn't happen very often. When you are writing a witness statement and you are expected to attend the hearing and be cross-examined, that's quite a scary prospect. How do we support our clients in that respect?
We try and break down the journey. So we've supported your hand, held your hand and supported you throughout the process to this stage. In preparation for a hearing, we'd arrange for counsel to attend with you. If there's a colleague that can join you at the hearing, we'd always encourage that they go also. It kind of brings the whole process into place. We wouldn't be putting you in this position without you being fully prepared and ready for what's coming at that hearing. It's nowhere near as daunting as what you might have seen on TV. So don't worry, and any questions or concerns you have, we're here to hear. So listen to those and help you get to that stage.
I was going to say run Poll of the Bailey, but I'm probably the only one that remembers that. There's a lot of TV reference today. Would you recommend, because I found this really useful, would you recommend if anybody had the opportunity to go to a hearing, whether that's in a court or tribunal, go and sit in and listen?
It kind of gives you a little bit more justification as to all the steps in the process, why the budgets are important, why the accounts are important, the relevance of a compliant demand. And it's another opportunity to kind of see that whole process come into play.
Yeah. I remember going to the tribunal for the very first time. In fact, the first time I went, I was a witness, and the barrister. I was going to say the barrister had made sure I was fine. They hadn't prepped me to that, unlawfully. But every time they wanted to ask me a question, the chair stepped in and said, "I think we'll take that as read as being okay. Can you move to your next question?" I didn't answer a single question.
Yeah,
and sometimes that's the case.
There's a couple of happy calls that we've had after hearings where the client's so pleased and they've had to say nothing. It's very limited. Sometimes the opposing party may not even attend.
Yeah, daunting prospect, but we'll hold your hand. Look, this is the end goal. This is where we want to get. And I appreciate that this morning's been quite a whistle-stop tour through recovering service charge. It's probably gone a lot quicker for us than we expected it to. But if you want to get paid in full, if you want that money, then we've got to get things right from the offset, like we said at the beginning. First off, we need to read the lease. We need to make sure that we're getting everything right that the lease tells us to. We need to make sure we're complying with legislation. We've got to get that budget right. Lots of information in that budget, so we are informing our leaseholders what it is they're contributing towards. Nice covering letter with the budget, making sure we get our demands right and sent out in a goodly, timely manner, compliantly with all the right enclosures. And then when it comes to the end of year, we're making sure that we're getting all our end of year accounts done, again, in the right timescale. And that's likely to only get even worse. I mean, we haven't even touched on the potential changes with the leasehold and freehold reform bill, of course. Lots more things coming down the line in relation to that. I'm sure there are lots of opportunities for webinars over the next few months, updating you guys on that. If you exhaust everything that you can do, and you still find yourself in a position where you need to refer that out, then of course you're going to have to do that. And your supplier, whether that's us or you've got a preferred supplier, is going to be working very hard on your behalf. They have that process to follow. And I think it's important then you need to manage your client's expectations. This letter of claim means that we've got to allow 30 days before we can do anything else. Or, though having said that, we will be making phone calls during that 30-day period. Once it's expired, we'll still try and close that out before we issue proceedings by going to the mortgage company. We have to issue proceedings, then we will. And we'll do that in as quick a manner as we possibly can. If we end up in court, then we're going to be standing by your side and supporting you. But our end goal is the same as yours, is to get paid in full. Look, I don't suppose anybody will mind if we do a little bit of self-promotion as we are delivering this, so apologies for the next couple of slides. But for when we get instructed on a matter, when something comes across to us, we have to carry out a compliance review. What does that compliance review look like and why do we do it?
I talked about a risk assessment when the defence is received. That's not the first time we're going to be checking to ensure that we are compliant. Upon our instruction, and the first thing we'll do is a conflict search, and then we'll also do a lease and compliance review, which will identify various terms within the lease that are important to us recovering those sums for you. We'll ensure that we're issuing the claims being proceeded in the correct entity's name. The entity has the actual ability to recover the service charges, to make sure the payment dates are correct, and make sure that if there's anything that's brought to our attention at this stage, you're aware of the same also. And it may be a case that we may need an authority to act. So we may say, if we're instructed on behalf of a managing agent, it may be a case that we need to get authority from the entity within the lease that gives the managing agents the authority to instruct us to proceed. It's important to get all of this right at the start, then be faced with these sort of questions when we're nearing a hearing.
Okay. So it's like the managing agent will do their own compliance review as they go along, making sure they're demanding right. We're just double checking and ticking those boxes. Yeah, you complied there. Yeah, you complied there. Right, we're good to go.
And also fixes. If it's found that, okay, when we missed something, we can give you a fix to fix this, so we're able to recover the sums for you. So it's just making sure that we can make your job as smooth as possible.
Okay. Yeah, we don't want to be getting to court for somebody to turn around and say, well, actually, you didn't do this, and then the judge throws it out and we have to start again. Okay, so if anybody did want to send any instructions across to us, and I'm not suggesting that you should, but you should. My contact details are at the bottom if you want to make contact. But what do we need from people?
In short, very little. Literally, name of your client, a statement of account, a copy of the lease if you've got one. Don't worry if you haven't. We can obtain that information from Land Registry. An email just informing us of your instructions, and we'll do the rest. So we'll carry out the lease and compliance check. We will have our very experienced payments desk team input the details on our system to ensure we can produce that letter of claim and start that recovery journey for you.
Okay, good stuff. And we'll recover 80% of that before we even issue proceedings. Right, let's end, before we go to questions, with kind of how we began. And you know, we looked at different elements that we felt were part of success to a managing agent. And we looked at those two at the bottom: the credit control process and having good cash flow, because we reckon if you get that right, then everything else kind of falls into place. You can add lots more, I'm sure, to what success looks like, but these were just things that we managed to pick out as being perhaps important things from our perspective. So I think that's just coming up for 10 to 11. Thank you very much. I don't know if Vicky wants to come back. I've seen some what appears to be questions forming in the box, Vicky.
Yes, yeah, there's quite a few, so I'll see if we can get through some and see how many we can get through. So the first one is, this was quite early in the webinar, so you may have actually covered some of this now, but can you please give your views on how the changes to the recoverability of landlord agent legal costs contained within the leasehold and freehold reform bill? It would appear to remove the ability to recover legal costs pre-legally and via MCOL. Money, same on.
Yeah, so it's one of the things that sort of referenced the leasehold and freehold reform bill. We are going to see potentially some massive changes, and one of those is that they are looking at recoverability of legal costs, and we're looking to see what happens. It's difficult to answer that completely until we know exactly what's going to happen. Do I think they're going to remove it entirely? No, I don't, but I don't have a crystal ball. Even before the leasehold and freehold reform bill came out in the King's Speech and was hastily drafted, dare I say, there was a private members bill that had its first reading in Parliament in relation to legal costs through tribunals and courts, and looking at a kind of grading system. So I don't think it will be withdrawn completely. I do think that there will be an element of us being able to recover legal costs on behalf of our clients. I think it might be limited to a degree, and then what we would then be needing to do is work very closely with our clients to understand how that affects them and how we can get over it. So I'll give you a better answer when I know exactly what's going to happen. But my view is I don't think it's going to be removed completely. That we may end up with a structured and maybe graded system.
That person didn't leave their name, but hopefully that helps. And if you want to follow up further, then you can get in contact with Mark and Faruq.
Yep.
Next question is a bit general. They want to know the difference between the sinking and reserve fund.
I think it's just semantics. I think it's just terminology. Unless you know any different, I just think they are kind of one and the same thing.
It's important to recognise what the lease refers to. So it's important to look at the lease and ensure that whether it makes reference to a sinking fund or reserve fund, and for us to assess that and kind of guide you as to what the differences are, and if there's any sort of specific questions that need answering around that. I think as a whole, it's a bit general, and we're more than happy to assist if we can.
Yeah, one of the things I will say is when you're looking at your lease, make sure you understand what your reserve fund or your sinking funds can be used for. So that's probably more important. Sometimes they're very limited in what you can use them for, but just check the terminology. It may be that you have a fund that you can only use for the lift, for example, or other engineering on site. So the differences between reserve and sinking fund, I think in part just like title. I don't think there's a great deal of difference between the two. The really important thing is understanding what that clause says you can use that money for.
If you've got a specific question, fire it over to us, and we'll definitely try and help where we can.
Yeah, again, that person hasn't left their name, but if you've got something that you'd like to ask specifically, then yeah, drop Mark and Faruq an email. Next one is from Ivan. Is a letter of claim needed for a pure FTT process?
I think I understand that question. If a leaseholder is going to go directly to the FTT, they would need to make an application as opposed to a letter of claim. We do find circumstances where we send out our letter of claim, and it may be a case that the leaseholder is challenging the reasonableness of the service charge, in which case the county court, who have these proceedings now, will transfer those proceedings to the FTT. The FTT, a number of years ago, launched a pilot scheme in which the FTT judges, the judges that sit in the FTT, can also wear the hat of a judge that sits in the county court. And they're still running with this pilot scheme because it seems to be working. There may be instances that once the reasonableness has been determined, it's then transferred back to the county court to determine the rest.
Yeah. The letter of claim, you'd use that if you were taking action ultimately through the courts. So if you have a debt that's owed by an individual, and that could be a sole trader as well, just not necessarily a business, but so it could be a sole trader, and you're acting for a business. So if you're acting for an individual, again, it doesn't count. But if you're acting for a business seeking a debt from an individual, you have to follow pre-action protocol, and you would then probably follow the route through the county court. I think if you're going to the tribunal, your action that you take would be slightly different. You'd probably ask the tribunal to be determining whether or not the service charges were payable, whether they were reasonable, and who they were payable by. So it's a slightly different process. So I wouldn't be issuing a letter of claim and then going to the tribunal, because I'm taking a slightly different route.
It may turn out that the tribunal probably don't have jurisdiction to deal with the issue. So, for example, if it's a transfer and not a lease that you're challenging, the tribunal don't have jurisdiction to deal with that, and then in which case a letter of claim is required.
Okay. Next question is from Melissa. There's two actually that are slightly linked. Are you able to contact mortgage companies for payment of arrears without having a judgment first? And then off the back of that, the mortgage companies stop paying arrears without a judgment first, but have they changed that now?
It's a real mixed bag. So the answer to the first question is yes. You can approach a mortgage company. You don't need to have issued proceedings. And as Faruq pointed out earlier on, if you write to the mortgage company, they're going to write to their borrower, and they will most likely have an up-to-date address, which we may not. And that could provoke a response, particularly if the leaseholder has had correspondence from the managing agent, has had correspondence from us and has ignored it, and now their mortgage company is saying, come on, you need to get this sorted. So it's a wake-up call. So I definitely would do it in that respect. And we also have to put the mortgage company on notice that the leaseholder is in breach. So we have a kind of an obligation to tell the mortgage company anyway. Your second question, the second part of that question, yeah, you're absolutely right. There are mortgage companies that have changed their process. So where a mortgage company feels that their security is at risk, so if we're acting for a landlord and forfeiture is a potential threat, they will step in and pay. Some will pay without a judgment. More often than not now, they are asking for judgment. Some might actually ask you to go even further than that and commence forfeiture proceedings, or at least serve a Section 146 notice. So it's a real mixed bag.
Okay, thank you. Hope that helps, Melissa. Okay, so Bestie has said, in regards to Section 146 notice, we've said we can issue this if we're acting on behalf of the landlord. Is an RTM or an RMC company a landlord for the purpose of this notice? Or does a landlord have to be the freeholder in this instance?
So the landlord is effectively the person that granted the lease or their successor in title. So you can only forfeit a lease if you granted it in the first place or you are the successor in title. So if an RMC, if the RMC were to purchase a freehold, which is kind of unlikely, you'd probably set up a freehold company to do that, then that organisation would have the right to forfeit the lease. Sometimes a developer will build a site and then once all the units have been sold, they gift, if you like, the freehold to the RMC. Again, they would have the right, but it has to be the landlord. If the RMC is just a part of a tripartite lease and their powers are only to manage the development, they're not a landlord. Again, an RTM company, the RTM takes on the management functions of the landlord, but they don't take on the right to forfeit. That's one thing they don't have.
Okay, we've got 4 minutes to see if we can get another one or two in. From Maria, can the reconciliation of accounts take place without having worked out the void schedule first?
Say that again. Can the reconciliation of accounts?
Oh, sorry, she had another question before this, so it's probably slightly linked. So first of all, she said the accounting year in the estate that she works in runs from the 1st of April until the 31st of March. The reconciliation for year 2022 took place in October 23, so really overdue. Does this indicate, or is it proof of non-compliance on behalf of the managing agent's side?
It would be important to recognise if there's a specific time period within the lease to provide those accounts. I think if you need to recognise this, by all means, like I said before, send us over a copy of the lease and we can try and review that for you and help if we're able to. But it is on a case-by-case basis. We would need to look at the lease to recognise what the obligations are within the lease to ensure that those accounts are produced by, and then and look at any sort of knock-on effects that has with any sort of demands that are being made following them.
Yeah, it's not against the current law. Let's say that, and I think most managing agents, pretty much all managing agents, will try and get their end of year accounts done, as we said, within 6 months of the year end. That's good practice. If you look at ARMA guidance, you know that's what they would recommend. If you look at the RICS residential service charge code, and I don't think the 4th edition is out yet. I think we're still working with the 3rd edition. Again, they would recommend that. Leasehold and freehold reform bill, there are parts there that are going to request that does happen, that it is 6 months as a deadline. But currently, if you overrun that, it isn't against the law. You're not going to have a problem in that respect. What you do have to be aware of, if you're going to overrun that time, is if I've got a balancing charge to demand, when did I run out of money during that year, and when does my 18 months run from? So you need to be very much aware of Section 20B in that respect. So accounts that are produced over 6 months after the year end, it's not good practice, but it happens. It's not against the law, but it might be. Just keep an eye on the leasehold and freehold reform bill. But be careful if you've got a balancing charge to make. Can you demand it, or are you out of time in that respect? So hopefully that's answered that.
Going back to Section 20B2 point as well, have you informed your leaseholders that this cost is going to be incurred?
Yeah. Okay. I think we're basically out of time. There's another 5 or 6 questions. So I can hand them over to Mark and Faruq, and then if you've got time and can contact those people, then that would be great. Otherwise, thank you both for your time presenting this morning. Thank you to everyone else who has joined us today. The slides and the recording will be available this afternoon for anyone that would like to see them. Otherwise, thank you and have a good rest of your day.
You too.
Thanks,
guys. Thank you.
all.
Bye.